Hello, all the CA Inter students. So today we are going to complete the chapter called as General Meetings in the Super 35. One very important chapter, and we covered 50 questions as of now. The balance questions also will complete totally 75 different types of questions we are going to do in this chapter called as General Meetings. I mean management and administration. Examination point of view, the extremely important area will be General Meeting. Okay, let us begin with the remaining area and let us try to complete. See there, question number 51. Examine the validity of the following with reference to the relevant provisions of Companies Act. The Board of Directors of Shrey Limited called an extraordinary general meeting upon requisition of members. However, meeting is adjourned. Same controversial question again. What is the actual answer? What is the institute answer? Now you tell me. The actual answer is meeting is called by Board of Directors on requisition of members. Okay. Actually, meeting will be adjourned if the quorum is not there. But what institute will write? Since the meeting is on the requisition of members, the meeting will be cancelled. That's what they will give the answer. Okay. 4-5 times same question came. First, write down what do you mean by the minimum quorum that should be present. Okay. Next, as per 103, if the quorum is not present within half an hour, okay, then if the meeting is called on the requisition, it shall stand cancelled. But this is a wrong answer. I told you so many times. Again, I am telling the answer. Meeting called by requisition is themselves will be cancelled. Okay. Just a meeting called by board on requisition of members will not be cancelled. It will be adjourned. Therefore, meeting is cancelled. This is institute answer. Okay. Next, second question. This is second bit. Mary Limited is a listed company having a turnover of 1200 crores during the financial year. This is exam question. This is RTP question where they are asking on 2 points. This is on general meetings chapter. This is on accounts of company. So we will discuss about this in the accounts of company chapter because this is relating to CSR. Relating to what's a CSR. Next. RTP November 21 question. Nutty Buddy Limited is manufacturing premium quality milk based ice cream in two flavors, first chocolate, second butterscotch. The company called its AGM in order to lay down the financial statement for the shareholders. AGM lo four things will happen. Consideration of financial statements, also called as the accounts. Second one, dividend declaration. Third one, director's appointment. Fourth one, auditor's appointment and remuneration fixing. However, due to want of quorum, meeting was cancelled. Also, the directors of the company did not file the annual return with the registrar. The directors were of the idea that the time of filing of returns is 60 days from the date of AGM would not apply as the AGM was cancelled. As the company contravened the provisions, of it will be penalized. Okay. Penalty, I already shown you, section number 92, 5 and 6. Okay, go to the penalty chart in the question bank and read and remember that. That you have to mug up only. There is no choice available. Okay, so with regard to the concept, what I told you, so many times same repeated question is being asked. In case of an annual return, okay, annual return must be generally filed within 60 days from the date of the annual general meeting. Okay, if the annual general meeting itself is not held by any reason or cancelled and not held, in such a case, you must file the annual return within a period of 60 days from the last date on which AGM should have been held under section number 96, along with the statement of not holding the AGM. So you must file even though the meeting is cancelled. Last date on which AGM should have been held, from that date within 60 days, you have to file it with the ROC, the annual return, along with the statement showing the reasons for not holding the AGM. Every company shall file with the registrar a copy of annual return within 60 days from the date of AGM. Where AGM may not held, within 6 days from the date on which AGM should have been held, with the statement specifying the reasons for not holding the AGM. For this, they will give the first 2 marks. Next, if you fails to file, penalty, minimum 2 lakhs, maximum 50,000, like that, all these things will happen. For this, another 2 marks they will give. Okay, this is a 5 marks question. In the instant case, the idea of the director, since AGM was cancelled, the provisions requiring the filing of annual within 60 days would not apply is incorrect. So the directors are incorrect. For this 1 mark. That's it. Okay. Next. 53. 53. So many times it was tested, and if you remember, one question like this is also asked in the basics means, I mean, in the first part of this particular general meetings question bank, but there I said that we will be discussing the proxy concept later. Okay, so therefore I'm not touching this now. This question and that question, two very big questions, 6 marks and 8 marks questions are there. Those I will discuss at the end of this general meetings chapter. Okay, in this lecture only, but at the end I will discuss. So please don't miss this particular question. Very, very important. Okay. Shall we begin? Yeah. See there, Abhiyogik Limited, having 1,000 members with a paid up share capital of 1 crore, decided to hold AGM on 21st of August 2022, and it received a notice on 2nd July 2022. It received a notice on 2nd July 2022 from its 60 members holding paid up share capital of 7 lakhs in aggregate for a resolution to be passed at the AGM for appointing Vedya and Co. as its auditor from financial year 22-23 onwards instead of existing auditor Chapel and Co., which was originally appointed for 5 years term and has completed its 4-year term. Such a notice for resolution was forthwith sent by the company to Chapel and Co., who gave its representation in writing to the company along with the request of its notification, but it was received too late, 3 days before, by the company. In the context of aforesaid facts, please answer to the following question: whether said notice was given by adequate number of members within the prescribed time limit to Abhiyogik Limited. Second, whether company was bound to send the notice to the member. This we will see in Audit and Auditors, chapter number 10. This question is based on 2 chapters. Number 1, management administration, special notice concept. And in the auditors chapter, removal of auditor, this will be there. So auditors chapter we are not going through now. We are doing a general meeting chapter. Therefore, auditor removal section we will discuss separately. I will be discussing about the special notice part in this question now. Clear? First, read the question before we go with the solution. Please, when I ask you, read the question only. Completed reading the question? See here. First point number 1, already we discussed what is a special notice. Okay, though this is a question answer session, I explained you the entire background behind special notice in the one of the lab sessions. Special notice is a circumstance where the member will give his intention of passing a resolution to the board of directors 14 days before the meeting, and the directors will circulate to the members within 7 days before the meeting, and then the special notice will form part of an agenda to the meeting which is already called. Special notice can be given 3 months before the meeting maximum, and minimum it must be given 14 days before the meeting. Okay, and it cannot be given by anyone. It should be given by such a number of members holding not less than 1% of the total voting power or 5 lakh in the paid up share capital. Okay, in this question, let us see how many are there. 1000. Okay, 1000 members holding not less than 1% of the total voting power. First, see here, 1 crore. Total paid up capital is how much here? 1 crore. 1 crore, 1% means 1 lakh, or that can be satisfied, or paid up share capital 5 lakhs should be satisfied. Both are satisfied here. So 7 lakhs worth 60 members are holding. They gave a notice, special notice for appointing some other auditor, some other person as an auditor in the place of retiring auditor. So we are not going to appoint the existing auditor. We are going to technically throw them out. So to do that, auditors can't be thrown by auditors or by directors. Members has to do. So idea comes to the members. How many members got an idea? 60 members got an idea. How many? 60 members got an idea. They gave which notice? Special notice. To whom? To the board of directors. Why? They are asking to conduct a AGM. Anyway, AGM is going to get conducted. In that AGM, we wanted to put this matter. Clear? Okay. After that, what are all the rights of an auditor for this? All these we are going to discuss in the audit chapter. That's what the second part of the question. Okay, sorry, second part of the question. The first part of the question, is the notice adequately given? The only thing we need to check is the time limit. Okay. When the meeting is going to get held? 21st August. When? 21st August. At least 14 days before you should receive. 2nd July I received. 14 days before or not? Yes. And it should be given by such a number of members, 60 members, holding not less than 1% of the TVP or 5 lakh paid up capital. 1% or 5 lakh, both are satisfied. So they can give a special notice or not? Yes, they can give. So special notice is required to pass a resolution. Then notice to move such a resolution shall be made by the company by the members holding not less than 1% of the TVP or 5 lakh rupees. The aforesaid notice shall be sent by the members to the company not earlier than 3 months, maximum 3 months, at least 14 days before the meeting. Okay, next. Here, Abhyogik Limited is having 1000 members with a paid up capital of 1 crore and received a notice from 60 members being 7 lakh capital. Okay, next, 7 lakhs in aggregate. On 2nd July, for resolution passed to be held on. As the members who gave the notice hold more than 5 lakh in paid up capital, they are eligible to give such notice. Further, it should be given not earlier than 3 months, but at least 14 days before the meeting. And the notice was given on 2nd July, which is within the prescribed time limit. Thus, it is said that the said notice was adequate. It was made by adequate number of members and within the time limit. Like this, you need to conclude your answer. About 140 subsection 4, we will discuss in auditors chapter, not now. Next issue. Question number 55. A and his wife B has a joint demat account in Vrinda Limited. The company's AGM is held on 28/8/2022. In such a case, who will cast the vote in the AGM? Give your answer as per the provisions of Companies Act 2013. Read the question properly before we go to the discussion. And honestly, please do this. Read the question only. Don't read the answer. Read the question properly. You have to write exam. So be serious about it. Okay, see here. Whenever there are joint holders, I gave a lot of time for you to read the question. If possible, you will try to read the act also. So that's why I gave time, almost around 3.5 minutes. Time was given for this. Why I have given is I am expecting this question to come in the exam. So please listen carefully. Whenever joint holders are there, whenever which holders are there, yeah, joint holders are there, means two people purchasing the shares jointly. Whenever joint holders are there who come to the meeting, both can cast the vote. No, both are not allowed. One can instruct another. They can tell that, for example, 100 shares are there, two persons jointly bought, 50% money given by A, 50% money given by B. Okay, 50% A, 50% B. If A attends the meeting, B will tell, for your 50 shares, you do whatever you want. For my 50 shares, vote in favor, vote in against, like that they will tell. That's a different thing. I'm not talking about voting on resolutions. Also, who will vote is a question now. Okay, who will vote? Who will have a right to vote? Both will go? No. Who will go? Those persons whose name is appearing first in the register of member, that we call as the seniority, means whose name appears first in the register, that person will be allowed to attend the meeting and vote thereat. Are you understanding the point or not? So who will vote? Such member whose name appears first in the register of members. Joint holders like A, B, C are their example. Okay, they have written B, A, C. Who's come first? B. So in B will be entitled to what? B does not attend now. Next one who? A. Like that we will understand. So that's a point. The voting in case of joint holders is done in the order of seniority. Means whose name appears first. Not age seniority, appearance seniority, which is determined on the basis in which their names appear in the register. The joint holder shall have a right to instruct the company as to the order, or they can only tell the order. Sir, first write A, next write C, next write B. Like that, they can also instruct. Okay, next. The scrutinizers, meeting started. What started? Meeting started. Okay. The scrutinizers shall arrange polling papers and distribute them to the members and proxies at the meeting. In case of joint holders, polling papers shall be given to the first named holder. Vote by poll. So then what will be the situation of vote by show of hands? If it is vote by show of hands, okay, when you raise the hand, number of votes will not be known. Number of shares will not be known. So vote by show of hands ki problem does not arise, whether you are joint holder or any other holder. Okay. Normally only you will vote. But when it comes to poll, okay, when it comes to poll, one share, one vote will be there. Therefore, if 50-50 amounts are there, for my 50%, 100 shares are totally bought. 50 shares are bought by A, 50 shares are bought with B's money. Totally 100 is a joint holding. Am I clear? So A will vote for 50 in the way he want. A will vote for the remaining 50 shares as B instructed A. Okay. So in what way they will be voting? Scrutinizers shall appoint polling papers for voting on poll and distribute them to the members and proxies. In case of joint holder, polling paper shall be given to the first named holder in the joint holding. And in the absence of a joint holder attending the meeting as appearing in the chronological order in the folio. Folio means a register. Chronological order means a date. Okay. Thus, in the given case, A or his wife B, whoever names first in the chronological order in the register of members shall be entitled to vote. So, who can vote here? Either the main person or whose name appears first in the register. That person will be doing the requirements under this particular section. So, who will vote in case of joint holding? Those whose name appears first in the register. Understood? Let us move on into the next one. Prabhas Limited. Prabhas Limited is a company having shares listed on recognized stock exchange. The company has 5,000 members. The annual general meeting of the company is to be held on 7/9/2022. As per the provisions of Companies Act, advise the company the remote e-voting and the period of closing the remote e-voting. Read the question first, later we can read. When I ask you to read the question, please read only the question. Hope you read the question. Okay, see here. Let me first explain the provision. With regard to the e-voting concept, every listed company and every unlisted company having not less than 1,000 members must provide an option of opting for electronic voting without asking them to attend the general meeting. Means what? If the number of members in a company is not less than 1,000, means 1,000 or more than 1,000, okay, even 1,000 also included, 1,000 or more than 1,000 members are there in a company must provide, or listed company irrespective of number of members must to provide for an option to go for electronic voting to vote at the resolutions in a general meeting. Okay, number one point completed. Number two, okay, number two, what is the question here? Some 7 9 something is given. Why? I will explain. When the e-voting process will start, we don't call it e-voting, we call it as a remote e-voting. We call it as a remote e-voting. Remote means what? Somewhere else other than at the place, far away from the general meeting place. Okay. For example, I am in Hyderabad. Meeting is held in Delhi. I am sitting in a remote place. From here, I am doing my e-voting. Remote e-voting process will begin 3 days minimum 3 days prior to the meeting and will complete by 5 p.m. of a day before general meeting. For example, today meeting is held. Okay, today general meeting is going to be held. Yesterday evening 5 p.m. Yesterday evening 5 p.m. all electronic voting votes will be stopped, and by that time all votes have to be coming. Next, maximum how many days I can give? That was not said. Minimum 3 days before. Minimum 3 days before it should start. And maximum I will entertain up to 5 p.m. of the day before the date of general meeting. So every company which is listed and company having not less than 100, not less than 1,000 members shall provide its members a facility to exercise their vote in form of electronic means. E-voting will open, okay, for not less than, means minimum 3 days it should open, and shall close at 5 p.m. Now see the question. AGM of the company is to be held on 7 9. 3 days before, 4 5 6, 4th 4 9 2022, minimum it should open and it should close as on 5 p.m. of 6 9. 5 p.m. of 6 9 4. That's it. Answer is over. Next. Question number 57. Question number 57. Okay. Sir, more about this I will discuss in accounts of company chapter. Reason I will tell you here. Okay. Reason I will tell you. This question is linked to 136 linked with AGM concept. You can see 136. 136 is talking about circulation of financial statements. Unless and until circulation concept you understand, you can't understand circulation for a Nidhi company. After understanding circulation for Nidhi company, then we need to link it to the AGM concept. So therefore, keep it on hold. Very, very important question, but we can understand if and only we complete 136. Next, 58. Explain the provisions of Companies Act 2013 relating to the quorum for a general meeting of a public company having total 30 members, of which 2 members are body corporate, 1 member is a President of India. Shall we continue? Yeah. Read the question first. Read the question first. Okay. Let us begin. Small question only. Quorum of a public company will be as decided by the articles. If articles do not decide any larger quorum, the quorum of a general meeting will be Like in case of public company, if the number of members as on the date of general meeting are up to 1,000, then the quorum must be minimum 5 personally present. And if it is 1,000 and 5,000 between, in such a case, it will be 15 personally present. And if the number of members of the company are above 5,000, then it will be 30 members personally present. In the given case, total number of members are 30. So it will come under slab 1. So technically the quorum for this particular company will be 5 members personally present. Proxies will not be counted for the purposes of quorum. Okay, next. Okay, next one. Quorum of a general meeting. See here. Explain the provisions of Companies Act relating to quorum for a general meeting of a public company having total 30 members, of which 2 members are body corporate. 2 members are body. As per section number 113, if the body corporates are members in a company, such a body corporate with the board authorization can appoint representatives on their behalf to go and attend at the meeting and vote thereat. The representatives so appointed are not proxies. They will have a right to vote. They will have a right to call for a poll. They will have a right to appoint proxies as well. Representatives will have all the rights and powers like a original member. Same applicable for President of India, but the section is section number 112. Body corporate 113 and this will be 112. Whether representatives appointed by body corporate and president to participate general meeting shall be counted for quorum? Yes, they will be counted for quorum. They are not proxies. They are representatives. And can they cast the vote? Yes, they can cast the vote. See, 113, 112. As per 113, if a company is a member of another company, it may authorize a person by a resolution to act as a representative. Then such person shall be deemed to be a member and counted for quorum. Same applicable for President of India. Done. Next question. If a member of a listed company who has casted his vote through electronic voting can attend general meeting of a company and change his vote subsequently and can appoint a proxy, listen. Point is, there are 3 questions here. How many? 3 questions. Question number 1. In case of a listed company, can electronic voting is allowed? Just now we read. Electronic voting system is mandatorily to be given to all the members in case of a listed company. 1 point answer came. Second, okay, once a member casted his vote, already he cast the vote, can he still attend a meeting? Yes, he can. The rules of electronic voting system says that any member who casted his vote by electronic remote e-voting, still they can attend the meeting, but they cannot vote again. They can't vote. They can't even change the vote which he has casted, because the voting will be completed by 5 p.m. of a day before the general meeting. Okay, next. Can he change the vote? No. Can he attend? Yes. So listed company, what you have to write in exam? Listed company must give a chance, opportunity or a facility of a remote e-voting to all the members. Number 2, here, any member who already casted his vote by remote e-voting, they can still attend the general meeting. Okay, and they can still attend the general meeting, but they cannot vote again, and they cannot change the votes which they have already done in the remote e-voting. Can they appoint a proxy? Yes, they can appoint a proxy, but proxy will not again get a vote. The notice of a meeting shall clearly state that members who cast their vote, okay, prior to the meeting may also attend the meeting, but shall not be entitled to cast their vote again. In the instant case, a member of listed company who has casted his vote through electronic e-voting can attend general meeting but cannot change his vote subsequently. Okay, for voting, he is not permitted to appoint a proxy. For voting, he cannot appoint. Normally, he can. Question number 60. Members of ZDA Limited holding less than 1% of TVP want the company to give a special notice to move a resolution for appointment of an auditor other than attorney. Okay, explain. Special notice, who can give? Special note, first you have to write about special notice as per section number 115. Okay, where any provisions of the act or articles require a special notice, then a member holding not less than 1% of the total voting power or 5 lakh in the paid up share capital can give a special notice to the board of directors not less than 14 days before the meeting, or not earlier than 3 months before the date of meeting. They can give a special notice. And special notice la only 4 cases will come under Companies Act. Removal of auditor, sorry, I mean not removal, appointment of another person as an auditor in the place of retiring auditor, or resolution expressly passed not to appoint the retiring auditor. Understood? Removal of a director, appointment of another director in the place of director so removed, or anything which is required by articles. In these cases, special notice can be given under Companies Act. Okay. Now the question arises. What he is asking here? Some group of members are there. They are not having 1% total voting power. They are having less than 1% TVP. Can they still give a special notice? Yes, provided they are having a paid up capital of not less than 5 lakh. All these things. In the above given facts in the question, there is a non-compliance requirements as stated above. The notice of intention to move such an appointment was given by holding not less than total voting power. This is the answer given by the previous examination question. Means what? Here, they did not tell about how much paid up capital they are holding. So therefore, you can write in 2 ways. Number one, assuming that they are having more than 5 lakh, 5 lakh capital. Since nothing is said, 1% of TVP is only not less than, sorry, less than 1% of TVP only they are holding. In that case, putting only this into consideration, can they give a special notice? No, it is a non-compliance. However, you can alternatively write another answer in exam. Even though they could not satisfy the 1% TVP condition, they are having not less than 5 lakh paid up capital, they can. So answer given in this particular suggested answer is they stopped with that 1% only. But in exam, you can also pinpoint about this 5 lakh. Are you understanding or not? You can pinpoint about this 5 lakh. Though 1% is not there, if they can satisfy this, that's why are holding shares, 5 lakh is the amount. If you can't satisfy that 1%, at least satisfy this 5 lakh amount. Please satisfy this 5 lakh amount. But institute answer is based on they are not holding 5 lakh, 1% condition only you need to consider. They are holding less than 1%, they cannot give a special notice. So this is one answer. Second answer, alternative answer is we can give the answer on 5 lakh basis. If 5 lakh is there, paid up capital held by those members, yes, they can give a special notice. Like that also you can add another answer. Next, X, a member of LKM Limited is holding 250 shares. How many? 250 shares. Yeah, 250 shares, which are partly paid. The company held its general meeting where the voting right was denied to X, claiming that he has not paid the calls on the shares held by him. Examine the value. Simply, already we discussed this. As per section number 106, if any member did not pay any calls or any lien is exercised on his shares for the debts due by him to the company, in that case, if articles allow the company, then the board of directors may restrict a member to cast his vote. In any case, any other reason other than these two, if the board obstructs a person from voting, that will become void. Company cannot stop a person from his voting right, except under 2 cases. Number one, first one, either non-payment of calls. Second one, lien on shares. And the most important condition is articles, this restriction must be there. The articles of the company may provide that no member shall exercise any voting right in respect of any shares registered in his name on which any calls or other sums are presently payable, or any right of lien. Okay, a company shall not, except on the ground specified, prohibit. That means only on the ground you can prohibit. Remaining grounds you cannot do. In the given case, okay, in the given case, 250 shares, he has not paid certain calls. Company denied his voting rights, etc. On examination of above facts, denial of X for exercising his voting rights is not valid. Why? Because, see here, X, a member of LKM Limited, partly paid. The company held its general meeting, has not paid any calls. Assuming articles of association do not restrict. Articles should restrict first. Then only board of directors can stop a member from voting. Since articles is not restricting you, you can vote even though calls are not paid. Next. Next one. As per the provisions of Companies Act, every company is required to file with registrar annual return prescribed under section number 92 in form MGD7. Explain the particulars. Okay, explain the particular. At the beginning, first class, I mean, in the Super 35 first lecture, I already given the answer for this. Okay, I told you that this is a expected question also for J25. Go back. I already discussed about this question. I don't want to waste the time. Next, Messrs. Techno Limited maintains a register of its members at the register office in Mumbai. A group of members residing in Kolkata wanted to keep the registers at Kolkata. I said now already, if 10% or more of the members, 1/10 of the total number of members, okay, resides in a particular place and a special resolution is passed, then you can change the register. Okay. So can a director inspect that register? No, only member. If you are a member come director, in capacity as a member, you can make an inspection, or else you cannot make the inspection of register. Same question already covered. Done. Go to the basics. First 2-3 questions I discussed about this. This also we discussed. Explanatory statement is required to increase the authorized share capital. Okay. Next. Anyway, I will again say tell about this. If you have any doubt, I will reconsider the question one more time. Okay. So see here, this type of question already we have considered before. So it's a so this question is something similar to what we have already considered. So let us have a glance about what is this question all about. First, Home Limited served a notice of general meeting upon its members. The notice stated that the following resolutions will be considered at such meeting. Resolution to increase authorized share capital, appointment and fixing remuneration of Mr. Pratik as an auditor. This is a special business. This is a ordinary business. A shareholder complained that amount of proposed increase and the remuneration was not specified in the notice. Is the notice valid under the provisions of Companies Act 2013? Okay, is a question that is being asked here. Please read the question first before we go into solution. Please read it properly. Okay, read it. Now listen. Why I first inform you that it's an ordinary business and special business. Ordinary business do not require any explanatory statement, but special business do require to give a explanatory statement. Okay. See, a shareholder complained that amount of proposed increase and remuneration was not specified in the notice. Okay. Remuneration must be specified because ordinary business lo 4 ordinary businesses are there. In that 4 ordinary businesses, one consideration of accounts, financial statements, board report, audited report. Second one is the declaration of dividend. Third one is the appointment of directors. Fourth one, appointment of auditors and fixing remuneration. So you should tell the amount of remuneration you are going to fix there. Very important thing is, what is an explanatory statement? Explanatory statement is required to be given for a special business. Then what is a special business? In a AGM, repeat, in a AGM, every resolution will be in a AGM. Every resolution will not be a ordinary business or special business. Any resolution or any business other than the four means what? Accounts, direct dividend, directors and auditors. Other than these four, any other thing is considered in a AGM, it will be considered as a ordinary business. Anything other than these four will be considered as special, deemed to be special. For a special business, it is required to give a explanatory statement. In the explanatory statement, you should clearly mention what is an explanatory statement. It should contain all the information. It should contain all the information which will enable the members to understand. The first one, whenever you give an explanatory statement, that explanatory statement should make the members understand the meaning. scope and implications of the resolutions and take a decision thereat. I repeat one more time. Explanatory statement should consist of all the material facts which will enable a member to understand the meaning, scope, and implications of a resolution and vote thereat. This is what exactly you need to write in exam. Okay. For example, if any director or KMP or his relative or any manager is having interest in any resolution, interest means if he is a partner in a firm, company is entering into contract with that firm, he is called as an interested director. That disclosures also you need to make an explanatory statement. So first, how to write an exam? Number one, you should first write about ordinary business, special business. As per section 102, there are two types of businesses. One is ordinary business, another one is deemed special business. What is an ordinary? Four are ordinary, you have to write the list. Other than those four, all other things are deemed to be special. With regard to the special business, company along with the notice, in the notice, they must give explanatory statement. In that explanatory statement, it should contain the interest of any director, KMP and their relatives. Number two, it should contain all the material facts that will enable a member to understand MSI, meaning scope and implications of a resolution, and take a decision thereat. In this particular case, company in the notice mentioned that it is going to increase its authorized capital, but it did not tell about the amount of increase, which is not correct. Okay, it will not give a full information. Amount of increase is a material fact as per the explanatory statement. So the contention of shareholder is correct, and companies not mentioning the amount of proposed increase is not valid. So first you need to write these points. Any other information, facts, meaning, scope, implication, etc. The information about amount is a material fact that will enable the members. Next, part 1 of the question relating to increase in authorized capital comes under special business. Hence, absence of proposed increase, the notice will be treated as invalid. Even in case of ordinary business, remuneration amount you have to tell. Okay, explanatory statement is not required, but you have to mention about the amount of remuneration that you are going to pay. So it is not a valid notice. Next, PQ Limited is a public company having its registered office in Mumbai. It has 3680 members, and company sent a notice to all the members of its general meeting on 2nd September 2019 at 11 a.m. at its registered office. On the day of meeting, there were only 12 members personally present up to 11:30 a.m. The chairman adjourned the meeting on the same day in the next week at the same time and place. On the day of adjourned meeting, only 10 members were personally present. The chairman initiated the meeting after 11:30 a.m. and pass resolution after discussion as per agenda of the meeting given in the notice. Comment whether the AGM conducted after adjournment is valid or not as per the provisions of section 103 of the Companies Act by explaining the relevant provisions in this regard. What would be your answer in the case if PQ Limited is a private company? Very good question. Read. Read the question first before we go with the solution. Read the question. Everyone, please read the question first. Let us see the question once. PQ Limited is a public company having its registered office in Mumbai. It has 3680 members. Public company with 3680 members means it falls under second slab. Therefore, 15 members personally present is required. The company sent notice to all the members for its AGM at 11 p.m. On the day of meeting, there were only 12 members personally present up to 11:30. It requires 15, but only 12 are present. So meeting was adjourned to the same day, same time, same place next week. Okay. Now, on the day of adjourned meeting, only 10 members were personally. At the adjourned meeting also, if the quorum is not present, the members personally present will form part of the quorum. On that, they ask the question. Okay. In case of a private company, 2 members personally present is a valid quorum if articles does not specify any larger number. Anyway, 12 are present. 12 or 10 in both the cases, quorum is present. First, you need to write the provision. Okay. So it requires how many members here? 15 members. If the quorum is not present, same day, same time, same place next week, or as the board decide. If at the adjourned meeting also quorum is not present, members present will be treated as quorum. In the instant case, there were only 12 members personally present by 11:30 on 12 September. Therefore, it was adjourned. Okay, it was adjourned. In the adjourned meeting also, if the required quorum is not present, 10 members will form part of the quorum. That's it. Next. Due to heavy rains and floods, Chennai Handloom Limited was unable to convene AGM. Same question, yeah. They don't wanted to file the annual return. What will happen? If you do not file the annual return, if you do not conduct AGM by any reason, okay, we are not telling that when floods are there to conduct AGM. What law says? You have to prepare and file the annual return within 60 days from the date of annual general meeting, or the last date on which AGM should have been held if the AGM itself is not held, along with the reasons in writing why you did not conduct the AGM. Same question again, I don't want to repeat. Distinction between ordinary resolution and special resolution. Listen, ordinary resolution and special resolution, there are two common points. Okay, number one, common point number one, notice must be duly sent. Second, both the places like this. Second, in case of ordinary resolution, the notice need not mention that it is an ordinary resolution, but in case of a special resolution, the notice should clearly mention that the intended resolution to be passed is a special resolution. Second very important point. Point number two. Point number two of this particular thing says like this. Whenever there is a ordinary resolution passed, okay, third point, okay, first one, notice must be duly sent. Second one, ordinary resolution ki notice need not mention that it is ordinary. Special ki you must mention that the intended resolution is a special. Two conditions satisfied. Ordinary resolution, third one, votes cast in favor should be more than votes cast against. Special resolution ki votes cast in favor must be at least 3 times the votes cast against the resolution, whether voted by poll or voted by show of hands or by proxies or anything, voting. That's it. That's it. Write about ordinary resolution, write about special resolution. That's it. You will get that 5 marks. 2 conditions for ordinary, 3 conditions for special. Next, examine the validity of the following statements. First AGM of a company shall be held within a period of 6 months from the date of closing of the financial year. No, it will be within 9 months from the close. Registrar may for special reason extend the time of first. No, ROC can extend only the time limit by 3 months maximum for the subsequent AGMs. Subsequent AGMs onwards, it should be held within 6 months from the closure of financial year. Yes. Next, there shall be maximum interval of 15 months between 2 AGMs. Yes, one AGM must be held at least. The gap between 2 AGMs should not be more than 15 months. First 2 are false, next 2 are right. Okay. Third right, fourth right. Incorrect, incorrect. First, second wrong. Third, fourth correct. Next. And this question was asked for 4 marks in exam. Just like that you can answer. Next. Next question. 5 marks, July 21. Mr. Laurel, a shareholder of Hardley Limited, a listed company, decides to inspect the minutes book of a general meeting and to have a copy of some resolutions. In the light of provisions of Companies Act 2013, answer whether he can inspect the minutes book and have the copy of minutes at free of cost. Whether he can authorize his friend to inspect the minutes book on behalf of him by signing a power of authority or power of attorney, anything you can call. Read the question first. Later we move on to the solution. Okay, read the question. Now, please see. I will first tell about the provision. Okay, first thing, point number one. Here, there are two things. Number one, inspection, taking copies. Two issues are discussed here. Whether inspection of minutes book by a member is allowed or not? Yes. As per section number 119, the minutes book of any proceeding, the minutes book of any proceeding, including the proceedings of a general meeting, okay, shall be open for inspection. Any meeting. Any meeting means I'm not talking about board meeting, committee meeting. General meeting, any meeting. Any general meeting, if any member wanted to inspect, can they inspect or not? Yes. The minutes book of general meeting proceedings will be open for inspection during the business hours by any member without payment of any cost. Inspection is free during business hours by any member. In case of taking copies of the minutes book, you can do that by putting a request. Company should provide you an extract or copy of the minutes book within a period of 7 working days from the date of making your request on the payment of some fees. However, agent appointment power of attorney is not allowed. Member only can do. Let's read. First write the provision in exam. The books containing the minutes of general meeting. So simply, minutes of a general meeting shall be open for inspection during business hours by any member without a charge. As is what I told you. Okay, next. Next one. Any member is entitled to be furnished a copy within how many working days? 7 working days, not 7 days. After he has made a request and on payment of a fee. So inspection ki no charge, but copy ki charge. In the given case, Mr. Laurel, in requirement of law, he can inspect the minutes book and soft copies up to last 3 years. If he want, yes, he can take it. No problem. As per the provisions, as provision does not specify anything about authorizing anyone else to inspect the minutes book. Therefore, Mr. Laurel cannot authorize his friend to inspect. Cannot. Next one. Explain the provisions of e-voting in an annual general meeting in the following cases. A and his wife B has joint demat account in Alpha Investment Limited. In such a case, who will cast the vote in the e-voting system? Okay, they are holding joint account. Whenever joint account is opened, who will vote? Just now we discussed. Whose name appear first in the register? Whose name appear first in the register? He will be entitled to vote. He will be entitled to the vote. If that person is absent to the meeting, then chronological order. Whoever comes next after that. So seniority is the basis. Voting in case of joint holders is done on the basis of order of seniority. Okay, that means the names appear in the register of members. Next. So the joint holders have a right to instruct, means whenever the joint shareholding is made, the joint shareholders has a right to instruct the company in which order they have to write, such that the first mentioned person has always a first right. If he is absent, then others will get the chance. Okay. So, as per the rule 21, the scrutinizer shall arrange the polling paper and distribute them to the members and proxies. In case of joint holder, the polling paper shall be given to the first name holder or in his absence, joint holder attending the meeting. Okay. Whose name appear, either A or wife B, whose name appear first will attend the meeting and vote thereat. Next. AGM is going to be held on 7/9/2020. Then what will be the e-voting period and time of closing? It starts 3 days before and 4th and ends on 5 p.m. of 6/9/2020. Correct. Done. Examine the following, okay, with regard to the Companies Act. Let us read the question first. The board of directors of a company refused to convene extraordinary general meeting of the members on the ground that requisition have not given explanatory statement for the resolution proposed to be passed at the meeting. The board of directors refused to convene extraordinary general meeting on the ground that requisition have not signed by the joint holder of the shares. Adjournment of extraordinary general meeting called upon the requisition of members on the ground that quorum was not present in the meeting. 3 questions, previous year paper, 6 marks, December 2021 attempt. Very, very important question. Read the question first before we go with the solution. Completed reading? Okay. Let's go into the provision and try to understand now. Will we continue now? Okay. Listen carefully. First point number one. What we need to understand is EGM, okay, EGM can be called in three ways. Number one, Sumoto board of directors themselves can call a EGM, or board of directors on the requisition of the members also can call a EGM. This question is on members requesting the board and board is calling a EGM. What they are telling is members made a requisition to the board of directors, please conduct EGM. Please conduct EGM. They said why they want the meeting, but explanatory statement they did not give for the special business. Therefore, board of directors said that we are rejecting your requisition because you did not give an explanatory statement. Point number one, common sense point number one. Explanatory statement to give members are chartered accountants, company secretaries, advocates, or any practicing person. They don't know that there is a concept of explanatory statement. Therefore, law said that explanatory statement headache is with the board of directors. Okay. If you remember EGM concept with a timeline chart, I said you, members will request the board by giving a requisition. Within 21 days from the date of receipt of requisition, board should proceed to call a EGM, okay, to conduct within 45 days of the date of receipt of requisition. That means board should proceed to call a EGM means board has to distribute the notices to all other members. Okay. Then at that time, board has to give the explanatory statement because they are having professionals on hand. So therefore, rejection of requisition of the members on the ground that explanatory statement is not given by the members calling the meeting, members requisitioning the meeting is not a valid ground. The no explanatory statement is required under 102 need to be annexed to the notice of EGM convened by requisitionist. And the requisitionist may disclose the reasons. May, not shall. Hence, board of directors cannot refuse. Remaining you can write. Okay, next. And moreover, whenever requisition is given, EGM must be requisitioned by 1/10 of the paid up share capital. Means, for example, 50-60 members are holding 10%. Now, all of them should sign. Okay. So, board of directors refuse to convene EGM on the ground that requisition have not been signed. It must be signed by the holders. Jointly, all are making application. All of them signatures is required. This is what they are. Next, adjournment of EGM called upon the requisition of members on the ground that quorum was not present. Okay. Again, controversial answer. This is the only answer which institute is not giving as per the norms of the Companies Act. Generally, again, same 10th time I am repeating this. Adjournment because of, okay, adjournment by adjournment of a EGM called by board. Okay, if the quorum is not present in a meeting called by board, adjourn. If the quorum is not present in a EGM, requisitioned by shareholders, members, and called by board of directors, adjourn. If the meeting is requisitioned by the members and board of directors refused to call EGM, then requisition is themselves called a EGM, and in that meeting, if the quorum is not present, meeting will be cancelled. So same. Institute will give a reverse answer. They will tell that any meeting which is even requisition by members or called by requisitionists themselves, both they will write cancel. But answer is absolutely wrong from the ICA point of view. This is the only controversial answer in the entire general meeting. Remaining all the answers they are giving as per Companies Act. Next. New Pharma Limited issued a notice for holding its AGM on 7th September 2020. The notice was posted to the members on 16th August 2020. Okay. Some members of the company alleged that company has not complied with the provisions with regard to the period of notice as such. Okay. 7th September 2020, notice was posted on 16th August. First point number one. What is the period within which it should be called? Notice must be given at least 21 clear days before the meeting. Okay, 21 clear days. Okay. Now, nothing is said in the question. Now we should assume that it is given by way of a post. Okay, so whenever you are giving a notice by way of a post, number one, you should exclude the date of notice, you should exclude the date of meeting. Okay, 2 days you need to exclude. Post another 2 days you need to add, 48 hours, 2 days you need to add. Okay. So when the notice is posted, 16th August. 16th August, notice is posted. Meeting on 7th September. Exclude this, exclude this, exclude another 2 days. Okay. 17th exclude, 18th exclude. From 19 you start count till 6th. 19, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30, 31. 1, 2, 3, 4, 5, 6. 15, 16, 17, 18, 19. 19 days only is there. Between this and this, I require 21 clear days, but only 19 clear days are there. Notice is not properly given. First, you need to write the point 21 clear days. If it is by delivery of post, you should take 48 hours after letter is posted. That's why after that, 2 days extra you need to add. Okay. Short by 2 days. Perfect answer. 19 clear days only is there. It is short by 2 days. Okay. Can you give a shorter notice? Yes. Conditions are there. Na? Shorter notice. In case of what? Annual general meeting, you should take the permission of not less than 95% of the total number of members. And then you can give a special notice. If there is a shortfall, how many days shortfall? 2 days. What is the length of serving the notice? Curtailed by articles of association. Okay. Length of serving notices can't be adjusted by articles. It was already given in the act. 21 clear days is given by act. Articles cannot reduce it. Companies Act does not provide anything specific regarding condonation of delay by giving a notice. Hence, a delay in giving the notice, calling agent cannot be condoned. Condoned means exempted, relief, no relief. Articles cannot reduce the time period of 21. Maximum what you can do is comply with the shorter notice conditions. Next. Next. ABC Limited is an unlisted company having registered office in Kolkata. AGM was held at Goa on 1st July 2021 at 3 p.m. and concluded on 8 p.m. Consent of all the members to conduct AGM at Goa were received by 24th of June 2021 by the email. Explain the validity of the meeting as per the provisions of Companies Act 2013. Okay. Next. State the consequences if a resolution has passed in such a meeting without sufficient disclosure regarding the interest of director. Read the question. Read the question first. Before we go with the solution, read the question. Completed. So first point number one, can we conduct in any other place other than at the registered office? Is a question. Okay. Let us understand the answer now. See here. First point number one. Generally, the annual general meeting of a company must be held during the business hours, that is from 9 to 6 o'clock, at the registered office of the company. If the registered office is not sufficient to conduct the annual general meeting, then it should be conducted at the same city, town, or a village where the registered office of the company is situated. However, in case of an unlisted company, AGM can be conducted at any other place within India if the consent of all the members is being taken. Okay. So first that points you need to write. Okay, all the members in advance you need to take. So therefore, in the given case, it was taken up. Yes, it was started well within the prescribed time. Next, business hours. Next, after that, Interest of director is not mentioned. I told you, whenever a special business is taken, okay. For example, related party transaction. Which transaction? Related party transaction, which says that if company enters into transaction with any individual or any firm in which a director is a partner, then for example, company is entering into transaction with a firm. In that firm, our director is a partner. Means indirectly, our director being a partner in that firm is getting a benefit or not. He need to disclose that interest. Okay, how you are interested in that firm in the explanatory statement. If you do not disclose, you should compensate back to the company whatever the profit you make in the transaction. This is what said in 1 or 2. So, what is an explanatory statement? In case of a special business, explanatory statement is mandatory. Explanatory statement should contain the interest of directors, KMP, promoters, managers, and their relatives as well. Okay. And it should contain all the material facts and information which will enable a member to understand the meaning, scope, and implications of a resolution and to take a decision thereat. I told you this statement just now in one of the question. Everything you need to tell. Where any special business is transacted, then explanatory statement should be annexed to the notice, which specify concern or interest of any director, manager, if any. Non-disclosure, any benefit accrues to the director should be compensated back to the company. Along with that, one penalty is there. Read the penalty chart. TST Limited has equity share capital of 10,000 shares of rupees 10 each. The company has received requisition from Mr. A and Mr. B, each holding 1500 equity shares, to call an EGM to remove managing director of a company who has been found involved in some malpractices. Okay. Company failed to call the meeting. Requisition decides to call the meeting themselves to pass a resolution. Explain the validity. Yes, already I told you. If the meeting is not called by the board of directors of the company, first of point number 1, who should give a notice of EGM? Members holding not less than 1/10 of the paid up share capital in case of company having share capital. This is a company having share capital 10,000. 1/10 means 1,000 shares. Each holding 1,500, 3,000 shares they are having. They gave a notice. Board of directors must call a EGM. They should proceed to call a EGM within 21 days to conduct a meeting within 45 days from the date of receipt of requisition. But they did not do. Then the members themselves can call a meeting. The requisitionists themselves can call a meeting under section number 100. Okay. They can call within 3 months from the date of deposit of the requisition. Same, all the things you need to do. 21 days they should proceed, within 45 days they should conduct. If they do not conduct, okay, within 45 days they have a right to conduct within 3 months. All the things what I explained, first you write down. Provision you write down, don't give conclusions first. Okay. So therefore board shall call. Any expenses incurred should be deducted from the remuneration of the directors, reimbursed to the requisition. In the given case, meeting is called by requisition to pass a resolution to remove managing director was valid, because it was given by members holding 1,500 shares into 10 means 15,000, 15,000 each. Okay. It is in compliance and will be binding on the company and its officers and employees, provided if all the conditions valid meeting are satisfied. Last one. The paid up share capital of Golden Shoes Limited is 25 lakhs divided into 2,50,000. Some of the shareholders holding 2,500 equity shares are residents of London for whom foreign register of shareholders is opened thereat on November 1st, 2022. Advise Golden Shoes Limited within how much time after opening the foreign register it is required to be filed to the register of companies a notice of situation of London office. Mark it very important. Chance is there. This can be given in the J25 exam. First read the question here, please. Don't read the answer. I can't cover the answer now. Honestly, read the question first. Understand what he is asking. Okay, completed? Listen first. The point is, companies should maintain register of members. That register should be kept at the registered office within India. However, in case of foreign members, debenture holders, or other security holders residing in a country outside India, with regard to their details, I can maintain the register. That part of register called a foreign register, containing the names and particulars of the members, debenture holders outside India, you can maintain outside India. However, whenever you keep a foreign register, within 30 days, within how many days, sir? 30 days of opening that foreign register, you need to file it with the registrar of company. In the given case, you can see some of the shareholders holding 2,500 equity shares are residents of London for whom foreign registry is opened in London itself. Yes, can we open? Yes, you can open, but November 1st, from here 30 days, you have to file it with the registrar. Which registrar? Where the company registry office is situated, that jurisdictional registrar you should file. The point. With this, we successfully completed general meetings chapter revision in Super 35. Okay, I will take all important concepts once after general meeting. I will take one other law, FEMA I will take. After that, I will be taking interpretation of statute. Okay, thank you very much. Meet you in the next session.